Hello everyone and welcome to class 24. Today's a pretty important class. We're going to be talking about the Sixth Amendment Confrontation Clause and how it relates to out-of-court statements and also to the other federal rules of evidence, particularly hearsay. After this, we only have 4 more classes, so we're rounding out and getting to the end of the semester. Today's lecture includes a lot of important Supreme Court cases. So we're going to talk about those, and when we get to an important case, I'll make sure to note it for you so you can kind of just keep in mind that that's something that you'll need to be familiar with for the exam. So you may all remember the class, this was a few classes ago now, where we talked about the trial of Sir Walter Raleigh, and that was in our Introduction to Hearsay class. There's a picture of Sir Walter Raleigh on the screen, and just as a reminder, this was the case that took place in England in 1602. Sir Walter Raleigh was charged with conspiring to assassinate King James I. Lord Cobham was the leader of the plot. And his trial essentially consisted of hearsay testimony and also testimony that violated the Sixth Amendment Confrontation Clause. So we learned that one of the individuals who testified against Sir Walter Raleigh was a police officer who had interviewed Lord Cobham and gotten Lord Cobham to confess to the plot and implicate Raleigh. And Cobham, of course, didn't testify at the trial. And he later actually recanted his confession, but the jurors didn't get to hear any of that. They just heard about the confession. There was also this peculiar testimony from a man named Dyer, who was a pilot who had been in Lisbon and had heard information from unknown Portuguese gentlemen that Raleigh and Cobham had conspired to assassinate the king. And so there were all kinds of eloquent protests that Walter Raleigh made to the judges to bring Cobham to the courtroom so that he could cross-examine him himself. He also protested against Dyer's secondhand report from these unknown Portuguese gentlemen. But ultimately, all of that stuff came in at trial, despite the fact that it was hearsay. And, excuse me, Raleigh was convicted of treason. So ultimately, he spent 13 years in the Tower before he was beheaded. And it later came out, and history at least suggests, that although Cobham did plot with others to overthrow the king, Raleigh was not involved in that. So a lot of the thought behind the Sixth Amendment, the Confrontation Clause, and also the rules banning hearsay are actually from the trial and sort of the injustice that happened at Sir Walter Raleigh's trial. Here's the text of the Confrontation Clause, and the 4 words that I have underlined are probably the most important words in that clause. So it says, in all criminal prosecutions, the accused shall enjoy the right to be confronted with witnesses against him. The 4 important words being criminal, accused, confronted, and witnesses. On the next slide, we'll talk about what those mean. So what do these key words tell us? Well, criminal tells us the context in which Confrontation Clause issues arise. They only arise in criminal cases. The accused tells us that the Confrontation Clause protects criminal defendants. It does not protect prosecutors. So it limits only evidence that's introduced by a prosecutor or by one defendant against another. It does not limit evidence that a defendant provides against the prosecutor. What about this word confronted? Well, we talked about that in an earlier class. Confront essentially means to cross-examine. So the Confrontation Clause has been interpreted as granting criminal defendants the procedural right to cross-examine witnesses. So then what do we mean by the term witnesses? Well, we've learned that a witness is pretty much anybody who testifies at trial, but in the Sixth Amendment context, the term witnesses is interpreted more narrowly. So a witness is a person who gives testimonial evidence for purposes of the Confrontation Clause. But we'll explore what that means and what testimonial is a little bit later on. To start, we can see that the court has interpreted the Confrontation Clause to read essentially like this. In all criminal prosecutions, the accused shall enjoy the right to cross-examine people who make testimonial statements against him. So where does this come from? I mean, prior to 2004, so fairly recent history, the Supreme Court in Ohio v. Roberts focused on reliability of statements. Excuse me, I have a little bit of a cold, so I'm going to try to get through this lecture without coughing too much, but it might be tough. So in Ohio versus Roberts, the Supreme Court focused on the reliability of statements offered against a defendant. So there the court held that the Sixth Amendment permitted hearsay statements if they carried sufficient indicia of reliability. So basically, as long as an out-of-court statement fell within a hearsay exception, then the court pretty much said there's no Confrontation Clause issues. So statements outside of those exceptions were inadmissible under the Confrontation Clause, but it sort of didn't matter because they were also inadmissible under the hearsay rules. Then in 2004, we have this case, Crawford versus Washington, which really changed the landscape of the Confrontation Clause. There, the Supreme Court held that this concept of reliability outlined in Ohio versus Roberts was too vague, and that the Confrontation Clause was meant to secure the the defendant's procedural right to cross-examine. Thus, it was not enough that an out-of-court statement fell into a firmly rooted hearsay exception. Instead, the court declared, if the statement is testimonial, the defendant has the right to cross-examine the declarant, even if the statement otherwise satisfies a hearsay exception. So that means on the final exam, if you get a statement, an out-of-court statement, and I'm asking you to assess its admissibility, you may have to analyze both the hearsay rules and the Confrontation Clause. What you'd want to do is you'd want to start by looking at the hearsay rules and determining, is this an out-of-court statement? Is it offered for the truth? If so, does it fall within an exception? If it's not admissible under the hearsay rules, then you can just stop there. There's no need to even explore the Confrontation Clause. If you find that it is admissible, however, under a hearsay exception, or perhaps it's not offered for the truth, it can come in for something else, then you have to analyze under the Confrontation Clause. Now, we'll get to this a little later, but if it's not offered for the truth, you don't have to worry about the Confrontation Clause. But if it is offered for the truth, you are going to have to do the Sixth Amendment analysis. Just because something is admissible as an exception to the hearsay rule does not mean that it satisfies the Sixth Amendment. So just keep that in mind. Okay, so Crawford is one of those important cases that I mentioned at the beginning of the lecture that would be useful for you to be familiar with for the exam. So I'm going to talk about that case for a moment. So in Crawford, Michael Crawford stabbed a man named Kenneth Lee in the torso. Crawford was charged with attempted murder, but he claimed he acted in self-defense. Crawford's wife was an eyewitness. She was present. She witnessed the stabbing, and afterwards she gave a taped statement to the police. And she gave the statement, by the way, while she was under investigation as a suspect herself. She was in the station house. The conversation ensued over several hours. And during the interview, she admitted to seeing no weapon in the victim's hands, which undermined Crawford's self-defense claim. So, of course, at trial, she invokes her spousal privilege, and her name is Sylvia. She did not testify. So the prosecutor sought to admit her taped station house interview into evidence. The Supreme Court ultimately held that the statement was testimonial because Sylvia was at the police station, she was responding to police questioning, and she was in fact in custody herself. So since Crawford had no opportunity to cross-examine Sylvia, the Sixth Amendment barred admission of that statement. So the takeaway from this case is that statements made in response to classic station house police interrogation will fall firmly within the definition of testimonial. Courts also have no trouble concluding that statements made during formal litigation, such as grand jury proceedings or pretrial evidentiary hearings, are easily testimonial. There, the witness is literally giving testimony, is literally on the witness stand under oath. So these declarants are witnesses in every sense of the word. But whether a statement falls into the category of testimonial is not always as clear as it was in Crawford. So we're gonna talk about some tougher cases in just a moment. We can build upon our understanding of the Confrontation Clause by articulating 5 principles that inform any Sixth Amendment examination of hearsay. First, keep in mind that all evidence must satisfy the federal rules of evidence. So you want to check that first. If the rules do not admit all evidence that the Confrontation Clause would allow. Again, the rules do not admit all evidence that the Confrontation Clause would allow. So if you find that a statement does not fit within an exception to the hearsay rule and it's offered for the truth, then you can stop there. In addition, the Sixth Amendment applies only to evidence offered against an accused criminal defendant in a criminal trial. So if the defendant offers the statement against the prosecutor, there's no Sixth Amendment problem. There's also no Sixth Amendment problem in civil cases. If the statement is non-testimonial, it will satisfy the Sixth Amendment. So it's important for you to understand what's meant by the term testimonial. The book gives some examples of some non-testimonial statements that are pretty easy to distinguish from testimonial statements. So some examples are statements that are sort of casual, off-the-cuff remarks made to family and friends, statement of a defendant, because defendants have no right to cross-examine themselves, or, the other thought behind it is if, he or she wants to, a defendant can always just take the stand. A statement of a co-conspirator during and in furtherance of a conspiracy is not going to be testimonial. If it's during the conspiracy, then it's certainly not made for the purpose of proving past events for future litigation. Also, most business records that are admissible under the business record exception are not testimonial because they're made for the purpose of handling business affairs and not for litigation. And then, as I mentioned before, if a statement is not offered for the truth of the matter asserted, then it's not testimonial and we don't have to worry about it. So just keep those examples in mind, but you should, to properly analyze whether something's testimonial or not, you should bear in mind the definition of testimonial, and the book gives several different formulations. The formulation I gave on the last slide is that testimonial really refers to statements given for the express purpose of establishing past facts of a crime or to identify a perpetrator. And at a minimum includes, for example, testimony at preliminary hearings, grand jury proceedings, sworn statements, police interrogation, things of that nature. But ask yourselves, are the circumstances of the giving of the statement essentially a alternative to live testimony? Would it appear that the witness would believe that her statement would be used in future litigation? So those are the types of questions to ask. So continuing on, we've got our last 2 principles. Number 4, if a statement is testimonial, the accused must have a chance to cross-examine the declarant. So again, if the declarant takes the witness stand and actually testifies at the trial, then we don't have a Confrontation Clause problem. It's only when the accused does not testify, or I'm sorry, when the declarant does not testify. And then 5, if there is no opportunity to cross-examine the declarant at trial, the prosecutor must establish, first, unavailability, so the declarant's not available for live testimony, and B, that the defendant had a prior opportunity to cross-examine the declarant. And this is a tough standard to meet. It's not just prior opportunity, but also similar motive. So similar to the hearsay exception for a former testimony, prior opportunity and similar motive to cross-examine, and that's pretty rare that a prosecutor is going to be able to show that. So most of the time, the Sixth Amendment requires simply that we remember 3 key rules and apply them, or that we remember these rules, I should say, and apply them. And then there are 3 key issues. What statements are testimonial? When is a declarant unavailable? And what constitutes a prior opportunity to cross-examine? Some observers also wonder whether the Supreme Court will ultimately one day scrap this entire framework because it is relatively new and the court's decisions are pretty fractured. We've got decisions that are basically commanding a 5-4 majority. But for now, we're going to assume that this is the proper framework because this is the framework that's currently in place. So what statements are testimonial? The courts have developed this primary purpose test that we're going to talk about. So again, I've already mentioned the easy cases, right? Formal statements made during litigation, a station house police interrogation after an emergency has ended, as in the Crawford case. These statements are testimonial because, again, they resemble a witness's in-court testimony, and they are made under circumstances that would lead an objective witness to believe that her statement would be available for later use at trial. Non-testimonial statements do not share these same features of in-court testimony. So records or statements that do not bear testimony against an accused. The example from your textbook is credit card receipts. Credit card receipts that a store keeps to secure payment. Those ultimately could be relevant one day in a criminal prosecution, for example, to show that a suspect bought tools for a crime from that store, but the receipt was not made in anticipation of litigation, so there's no Confrontation Clause problem. There are tougher cases, though, cases made outside of the classic police station house interrogation context. Here, courts have developed this primary purpose test that focuses on whether the primary purpose of the statement was to prove past events that are potentially relevant to a later criminal prosecution. This is an objective test. The judge asks whether a reasonable person would have believed under the circumstances, taking into account all relevant factors, including the perspectives of the speaker and the listener. So what would a reasonable person have believed about the statement? There are 2 cases that apply this test that were in your reading for today that are also important to know and be familiar with. The first is Davis versus Washington. This is the case where there's a domestic violence situation going on between Davis and his girlfriend. The girlfriend calls 911 to report what appeared to be an ongoing domestic assault by the defendant. During the phone call, she described to the 911 operator what Davis was doing to her as he was doing it, and she gave his full name. Davis was ultimately prosecuted for the assault, and the girlfriend failed to appear at trial. The Supreme Court there held that the girlfriend's statements to the 911 operator, and the court assumed that the 911 operator was law enforcement, that the statements were not testimonial, and there were 4 main reasons for this holding. One is that the girlfriend was speaking about events as they were happening. 2, she was facing an ongoing emergency, and her statements were a call for help. So they weren't, at that moment in time, they weren't to establish past facts that could be used or relate to a later prosecution. The questions that the 911 operator asked were necessary to respond to that emergency. And then 4, the statement was frantic. It was over the phone. It wasn't sort of calm and formal and considered like the station house interrogation in Crawford. So ultimately, the court held that the primary purpose of the statements in that case was not to prove past events potentially relevant to a later criminal prosecution, but instead to seek help in getting a response to an ongoing emergency situation. The next important case in your reading is Hammond versus Indiana. This was the case where police responded to a report of a domestic violence situation at the Hammond home. So again, we've got another DV call. When the police arrive, they find the victim wife sitting outside of the house on the front porch. They are able to remove her from Hammond. They secure the scene. They question her in the living room of her house, and she ultimately gave a statement identifying Hammond as her abuser. She signs a battery affidavit. Now at trial on the battery charges, the wife, of course, refuses to testify, so the prosecutor sought to introduce her affidavit and oral statement to the police. Now the Supreme Court, in contrast to the Davis case, held that these statements were testimonial because they deliberately recounted past events in response to police questioning. And it really didn't matter that she was at home. So this case certainly tells you that questioning by police, in order for it to be considered testimonial, it doesn't necessarily have to be at the police station or a police car. It can even be at a victim's home. It didn't matter because the threat had ended and because she was separated from Hammond, the defendant. These questions were really not designed specifically to address an ongoing emergency. Instead, it was really to gather facts to use at this later prosecution. To properly apply the primary purpose test, we must ask ourselves whether there is an ongoing emergency. That's kind of what we get from those two cases. There's this third case that you read, also another important one for the exam, Michigan versus Bryant. And that one fell in between the facts of Davis and Hammond, and the court really did divide over how to handle it. So this is the case where a victim was shot and was able to drive a short distance to a gas station and get out of his car. He was lying on the ground of a parking lot of a gas station and was just in a lot of pain, clearly in very serious condition. And when officers arrived on the scene, they started questioning him about what happened, who shot him, where did the shooting occur. The victim incriminated a man named Rick and described Rick's house. He later died. Officers went to the house and they arrested the resident, who ended up being Richard Bryant. And the prosecutor relied on the victim's hearsay statement to the police, identifying Rick as his shooter at trial. And of course, Bryant objected, claiming that this violated his Sixth Amendment confrontation right. The court really struggled with this case and how to handle it, and that's why you have such a fractured Supreme Court decision. So the circumstances shared some of the testimonial characteristics of Crawford and Hammond. For example, the shooting was over when the police arrived. The conversation that the police had with the victim was separated from the crime scene. The police asked very deliberate questions aimed at identifying Bryant and getting details of his crime. But the circumstances also shared some non-testimonial characteristics of the Davis case. So when the police arrived on the scene, they did not know where the victim had been shot, and they questioned him in part just to determine whether the shooter was still a threat, so whether the shooter was close by and still presented some sort of danger to the police or to other people. Also, the victim's statement was not calm and deliberately recounted. His injury hindered his ability to give that kind of a statement, He responded to questions, but the scene was chaotic. It was fluid. There were many officers involved. So the court differentiated it on that ground as well. Differentiated the statement from Hammond and from Crawford. So ultimately, the court focused on those latter factors, and a slim majority of the court held that the victim's statements in that case were non-testimonial. So what does Bryant do? Bryant really expands the number of statements that will come in under this primary purpose test by broadening the scope of what constitutes an ongoing emergency to include perceived threats to officers or to the public at large. So courts must look at the totality of the circumstances to determine whether there was an ongoing emergency at the time the statement was made. So now for a news story out of Missouri. This is an interesting one. It's actually a true story, because you all know that I like to find strange true stories to use as examples of evidence in this class. This one didn't produce any court case, so we're going to have to make the rest of this up. But the underlying story is true. So police in Missouri arrested a man named David Thies for possessing a hallucinogenic toad. They claim that he had planned to get high by licking the venom glands of this Colorado river toad. But we know that prosecutors rarely settle for charging just drug possession. They like to charge drug distribution as well. So to make this more interesting, let's suppose that the prosecutor claims that Thies rented his toad out to his friend Jerry. And based on that, the state charges David Thies with distribution. Now at trial, at David's trial, Jerry takes the Fifth Amendment and refuses to testify against his friend. So the state needs some other evidence to show that Jerry was using David's toad. The state produces Jerry's doctor, who will testify that Jerry came to her feeling quite ill. Jerry then made these statements to the doctor, and they're on your screen. So Jerry said that he was coming down from a bad high and that he had, quote, taken some toad. So first consider the rules of evidence. Consider whether this statement is admissible under the federal rules of evidence that we've talked about. Jerry's statement to the doctor was made out of court, and it's offered for the truth of the matter asserted that Jerry had taken some toad. So it is hearsay. The question is it admissible as a statement made for medical diagnosis? So this would be a good time to pause the video, head on over to Top Hat, and plug in your answer, and we'll see how you did when you press play again. Okay, so the answer to this one is yes, probably at least yes. It does seem reasonably pertinent to Jerry's medical diagnosis and or treatment. The doctor needs to know what substance might have caused Jerry's illness. Plus, Jerry didn't name anyone. He's not blaming anybody. This exception doesn't have a trustworthiness caveat, right? So we don't have to worry about that. Note that the statement will not qualify as a statement of an opposing party, since David, not Jerry, is the one on trial. So the prosecutor can invoke this exception only if she can show some sort of conspiracy between David and Jerry. And even then, this statement would have to be in furtherance of the conspiracy somehow, which just doesn't seem likely on the facts that I've given. So that's why it would have to fall, I think, under the statement for purposes of medical diagnosis or treatment. What about the Sixth Amendment? So turning away from the federal rules into the Sixth Amendment, does admission of this statement comply with the confrontation clause? And you've got 4 options on your screen. Again, now's a good time to pause, head over to Top Hat, answer this question, and when you return, we'll find out the answer. Great, so the answer to this one is yes, the statement satisfies the 6th Amendment. In other words, we don't have a confrontation clause problem. A statement to a doctor under these particular circumstances doesn't seem testimonial at all. I mean, Jerry's just seeking treatment at this point. He's not making a statement in anticipation of any kind of litigation. If it's not testimonial, of course, the 6th Amendment does not require cross-examination. So let's review how we know whether a statement is testimonial or not. Here are the 3 factors that, as a practical matter, seem to make the most difference, and the Supreme Court has referred to these factors, and lower courts often will respond to them. So we've got formal proceeding, solemn oath, that's going to be testimonial. Government involvement oftentimes is going to be testimonial, though not always. And then probably most importantly, a statement made to prove a past fact or a past event related to a crime. Courts often will use this phrase. Statement that declarant reasonably would expect to be used prosecutorially. But that really is often just a summary for a decision made on these other 3 grounds. And note, just keep in mind that several of the justices have shown increasing dissatisfaction with the definition of testimonial, as well really as with the entire approach of the 6th Amendment. At this point, however, other formulations have not yet won a majority of the court's support. Here's a different type of situation. Let's say that the United States prosecutes Daryl for murder, claiming that Daryl stabbed Vince. Daryl admits to stabbing Vince, but he claims self-defense. He thought Vince was going to shoot him. To suggest that Daryl's belief was unreasonable, the prosecutor calls eyewitness Wendy, and she's going to testify for the prosecutor. Vince said, "I won't hurt you. I just want to talk." May Wendy testify about Vince's statement? Here we're going to combine both the rules, the federal rules of evidence and the 6th Amendment. You have 3 options. Vince's statement is hearsay that doesn't fit any exception. And remember, the statement is, I won't hurt you, I just want to talk. Or no, it violates the 6th Amendment, or yes, Wendy may testify about the statement. So pause this video for a moment, head over to Top Hat, answer that question, and then we'll go over the answer. Okay, welcome back. So the answer to this one is 3. Yes. So if you picked yes, you got this one right. Wendy may testify about Vince's statement. It is not hearsay. Remember, it's offered just to show what Daryl heard. So I mentioned that the reason the prosecutor wants to use the statement was to suggest that Daryl's belief in the need to use self-defense was unreasonable. So because it's not offered for the truth, but just offered for its effect on the listener, then it doesn't present a hearsay problem. The statement, of course, affected his reasonable belief about Vince, whether or not Vince was speaking the truth. And since it's not hearsay, we know that it's not going to be testimonial. So this does not raise any 6th Amendment issues. Another way that you could analyze this problem, rather than analyzing the statement as not hearsay is you might have concluded that the statement satisfies the state of mind exception. And that would have been fine too. I think it does satisfy the state of mind exception in terms of telling the listener what was on Vince's mind, his plan, right? I won't hurt you, I just want to talk. And the statement was to a private person. Certainly it doesn't have any of those testimonial characteristics that we've talked about so far. Now here's another good example to talk about. Remember the Boston Massacre? Excuse me. The government prosecuted British soldiers who fired into a crowd of people, and if you recall, the defense claimed that the soldiers were provoked and had feared for their own safety, and so that's why they fired into this crowd. A doctor testified for the defense, and the doctor said, shortly before dying and believing death to be imminent, one of the victims said the crowd provoked the soldiers. So one of the victims told the doctor the crowd provoked the soldiers. So your question, again, if you head to Top Hat, is would the doctor's testimony about the victim's statement be admissible today under the Confrontation Clause? And you've got 4 options. No, it doesn't fall within any hearsay exception. No, it violates the 6th Amendment. 3 is it depends on the 6th Amendment status of dying declarations. And 4 is yes. So pause the video and answer this one, and then we'll talk about it. So the answer to this one is yes. The doctor's testimony would be admissible even under the Confrontation Clause. So the victim's statement seems to fit the dying declaration exception. So we can cross out 1. We know that it will satisfy the federal rules of evidence. And the 6th Amendment doesn't apply. Why does the 6th Amendment not apply? Maybe some of you caught this. My guess is not everybody caught this. But the 6th Amendment doesn't apply because the defense is the one offering the statement. So the defendant is the one who is calling the doctor to testify as a witness to what the victim said. Because in this scenario, the victim's statement actually supports the defendant's theory. And so if you'll recall, the Confrontation Clause is sort of a one-way street, right? It only protects statements offered against a criminal defendant. But a criminal defendant can offer a testimonial statement against the prosecutor. That's perfectly fine. It's really a rule that protects criminal defendants only. So in this case, we don't need to worry about the 6th Amendment treatment of the dying declaration exception. That would only be something to consider if the prosecutor offered the statement against the defendant. So I'm sure you all remember this interesting case from our online lecture about the co-conspirator exception to the hearsay rule, the Hollywood bling ring. So again, this is a true story. Several teenagers stole clothing and jewelry from various celebrity homes, including Paris Hilton, Lindsay Lohan. And here are 2 of the suspected thieves on the slide. You've got Nick Prugo on the right, who posted this picture on Facebook, and Rachel Lee is shown as well. So all 6 of the ring members, including Nick and Rachel, have been charged with these thefts. Suppose that Rachel Lee had decided to cut a deal with the prosecutor and that she testified before the grand jury incriminating the other 5 in return for a reduced sentence. She's supposed to testify against her friends at the trial, but when she gets on the stand, she claims the 5th Amendment and refuses to testify. So I'll give you a minute just to look over those basic facts. So another top hat question. You can head on over. The question is, when Lee refuses to testify, can the prosecutor introduce her grand jury testimony against the other people involved in the ring? Yes, because she's a co-conspirator, or yes, this is a prior statement and Lee is available, or no, this violates the Sixth Amendment. So pause the video, record your answer on top hat, and then we'll review this one. Great, so the answer to this one is no. This testimony would violate the Sixth Amendment, or this out-of-court grand jury statement would violate the Sixth Amendment. So although Lee has previously testified, if you'll recall, when we talked about grand jury statements, they're very one-sided. The prosecutor is questioning witnesses, the defendant's not present, nor is the defense attorney. The defense attorney does not have an opportunity to cross-examine the witness. And in a case like this, even if the defendant had a prior opportunity to cross-examine the witness, like the former testimony exception, he must have had a similar motive in cross-examining the declarant. This statement probably doesn't satisfy any of the hearsay exceptions either. It's not a statement of a co-conspirator because, again, this is after the conspiracy is ended. It's not furthering the conspiracy. It's not meant to further the conspiracy. It's not a prior witness statement because she's not available. So under the 801D exception for prior witness statements, if you'll recall, the witness has to actually be on the stand at the current proceeding testifying. And in this case, she has pled the Fifth and refuses to testify, so that eliminates that exception. It's not on the slide, but what about the former testimony exception? Think about why the former testimony exception would not work either. The reason the former testimony exception would not work is because, again, the defendant had no chance to cross-examine the witness at the grand jury. Even if some exception, if you were to come up with an exception that applies here, the statement would still be inadmissible because it violates the Sixth Amendment. Grand jury statements clearly are testimonial. There's no dispute about that. And Rachel isn't currently available for cross-examination, and the defendant had no prior opportunity to cross. Let's try another hypothetical, a hypothetical murder at the mall. Helga's body was found at the mall. She was stabbed to death, and she was stabbed to death with, we'll say, this knife here. Just before she left the mall, Helga told her mother, "I'm going to meet Larry at the mall." Larry is Helga's jealous boyfriend, so police are going to focus their suspicion on him. Larry claims, however, that he was at home during the time of the crime, and police are unable to find anyone who saw him at the mall. So this one is not a top hat question. You do not need to go over to top hat, and that is because there's no clear right answer to this question. So the question is, can Helga's mother testify about Helga's parting words? In other words, that Helga said, "Larry and I have a date at the mall." So although there's no single correct answer, there are two answers that you can cross out that are incorrect. The Sixth Amendment does not create any sort of problem in this case. It presents no problem. The statement occurred before the crime to a private person, and there's nothing testimonial about this. The prosecutor can forget about the Sixth Amendment, but he does have to find a hearsay exception that fits. This is not a statement of an opposing party. Helga is a victim, and if you'll recall, a victim is not considered a party for purposes of that exception. And there's nothing, we don't have anything to prove that she and Larry were co-conspirators. So admissibility really boils down to whether the statement fits within the state of mind exception or not. And if you'll recall, when we talked about the state of mind exception, I told you about the Hillman doctrine. So under the Hillman case that we studied, this would be admissible, right? It implies that Helga's intent, that Helga had an intent, and that was to meet Larry at the mall, right? And state of mind exception, as you know, covers the declarant's plan, motive, or intention. So this provides circumstantial evidence that Larry would be at the mall. But it appears that the drafters of this rule wanted to ultimately reject Hillman, and some courts do reject Hillman. In that case, the mother can testify about Helga's personal intent to go to the mall, but cannot mention anything about this third party, about Larry. So not the reason that she wanted to go to the mall. So if you're struggling with that one at all, just go back and take a look at the lecture on the state of mind exception where we talk about the Hillman case and the Hillman doctrine. And an important point to remember is that the federal rules of evidence in this case, in this example in particular, may impose stricter limits than the Sixth Amendment, right? Because here we don't have a Sixth Amendment problem. And ignore the placement of these two arrows because they're not really in the proper place. Okay. So the last major point of this chapter was, how does the Confrontation Clause deal with forensic evidence? And you've got two important, well, more than two really, I think at least three important cases to be familiar with out of this section. The Supreme Court is sharply divided on the admissibility of lab reports prepared as part of a criminal investigation. So you've got the first case, Melendez-Diaz versus Massachusetts, and that's a really important one about the admissibility generally of lab reports under the Sixth Amendment. So there, the defendant was charged with cocaine trafficking, and at trial the prosecutor introduced several bags of a white powder substance that it claimed contained cocaine, and also sought to introduce 3 certificates for a state drug lab declaring the substance was cocaine and noting the weight of the substance. The technicians who prepared the certificates swore to their truthfulness before a notary, but did not actually appear at the trial. The Supreme Court held that the lab reports were testimonial statements requiring cross-examination. The reports were clearly affidavits, which fell within that core class of testimonial statements because they were made for the purpose of proving some fact regarding the defendant's crime. And they were made under circumstances that would lead an objective witness to believe that the statement would be available for use at a later trial. So that was the holding of that case. The court also opined that the burden is on the government to procure the lab analyst for trial. Next we have Bullcoming versus New Mexico, which was sort of an uncontroversial case and an extension of Melendez-Diaz. So in this case, the Supreme Court essentially reaffirmed its holding in Melendez-Diaz as it related to a non-notarized certificate, because the certificate was still made for the purposes of proving some fact related to the defendant's past crime. So it didn't matter to the court that this was less formalized, that it was not notarized. It resembled the Melendez-Diaz report in all important respects. So these two cases have been understood to stand for the proposition that lab reports are non-testimonial if made under circumstances that would lead an objective witness reasonably to believe that the statement would be available, or I'm sorry, I said non-testimonial. I should have said that the lab reports are testimonial if made under circumstances that would lead an objective witness reasonably to believe that the statement would be available for use at a later trial. I should also mention that the Bullcoming opinion held, the court there held that a substitute lab analyst would not suffice, right? That the government had to produce the analyst who actually prepared the certificate or the testimonial report. And then we have this sort of interesting case that disrupts the sort of common sense holdings of the Melendez-Diaz and Bull-Cumming cases. Those two cases offered some pretty clear guidance, but in 2012, Williams comes along, and that case really has created confusion for attorneys and for judges alike. So in Williams, a woman was raped and she was robbed. She went to the hospital where attendants took a vaginal swab and sent it to the Illinois State Police. The police sent the sample to a lab for DNA analysis, and the lab analyzed the DNA on the swab, and what they ultimately did is they were able to create a DNA profile of the individual who raped her. At this point, the police did not yet have a suspect in mind for the rape. Ultimately, the lab was able to match that profile that they created from the vaginal swab with a man named Sandy Williams, whose blood had been profiled in connection with an unrelated case. Williams was charged with the rape and with robbery. The analyst who created the old profile from Williams' blood was present for cross-examination, but the state did not call any of the analysts who had created the DNA profile from the rape kit because those analysts were all out of state. So the defendant challenged introduction of the swab profile under the Sixth Amendment because he had had no opportunity to cross-examine the analyst who generated their report from the rape kit. So the court ultimately, in a fractured 5-4 decision, held that the report outlining the DNA profile created from the swab was non-testimonial. And that was essentially because there was no rape suspect in mind when the report was authored. That's what made it, in the court's mind, or at least the majority's mind, non-testimonial. But we also have these interesting plurality and concurring opinions. So sorry, I'm struggling with this word tonight. Plurality of the court developed what's called the targeted individual test, which essentially created a new definition of testimonial that had never appeared in the case law before. Evidence is testimonial only when it has the primary purpose of accusing a targeted individual of engaging in criminal conduct. And in this case, there was no suspect in mind when the DNA profile was created. So this is really is a narrowing of Crawford's definition of testimonial. Justice Thomas, on the other hand, rejected the targeted individual test, but ultimately concurred in the plurality opinion based on his own sort of test that he came up with. He's the only judge that subscribes to this formality test and concludes that the DNA profile was non-testimonial because it was not formalized. It was a bare report that certified nothing. So we had this sort of strange fractured opinion where a majority of the court holds that the profile was non-testimonial, but for different reasons. The dissenting justices, on the other hand, rejected both of these two tests and have adhered to the strict language from Crawford, Melendez-Diaz, and Bull-Cumming, which defines testimonial evidence as a statement created to establish some fact in a criminal proceeding and under circumstances that would lead an objective witness to reasonably believe that it would be available for later use at a trial. So how do we synthesize these cases and make any sort of sense with them? The way that I've done it is summarized for you on the screen. If you get a lab report that does not target an individual and is not formalized, then it's going to be non-testimonial, and that was essentially the holding of Williams. On the other hand, if you get a lab report that does target an individual and is formalized, that's sort of the easiest one. That's going to be testimonial. A lab report that does not target an individual but is formalized is also probably going to fall into the testimonial ground because of Justice Thomas, right? So the Thomas concurrence suggests that what matters is whether the lab report is formalized or not. So Thomas would have gone with the dissent in Williams had that report been formalized. And then finally, a lab report that targets an individual but is not formalized is going to be testimonial. It seems that every justice on the Supreme Court, except for Thomas, would rule that way. Okay, so I believe this is our final hypothetical for this class. So this is a drug prosecution. Suppose that we have a routine prosecution for the sale of cocaine. The government, of course, must prove that the substance offered for sale by the defendant was, in fact, cocaine. So they ask the crime lab to analyze the substance, and bingo, it's cocaine. So let's say that calling the lab technician to testify about his work, he would interpret his work. And it's sort of silly to have him testify live because he tests these substances every day, right? And he can't really remember this particular case or this particular substance. So the analyst prepares a nice certificate that looks kind of like this, right? Saying he certifies that he tested the powder that was submitted by the police department and it was found to contain cocaine. And he has the certificate notarized. So is the certificate admissible without any supporting testimony from the lab analyst to prove that the substance was, in fact, cocaine? So again, for this one, I want you to head on over to Top Hat, pause the lecture, and answer, and then we'll review. Okay, so the answer to this one is no. The certificate would be inadmissible without the analyst supporting testimony to go along with it. It's hearsay, right? It's an out-of-court declaration. It's offered in court to prove the truth of the matter asserted, which is that the substance tested was, in fact, cocaine. It doesn't qualify as a public record because it's a matter observed by law enforcement personnel, and those aren't admissible against criminal defendants. And Melendez-Diaz really clarified this, but if you need further review, see Chapter 46, which you can review this concept. The record can't qualify as a business record because a public record must satisfy this more restrictive public record exception. So it can't come in under the more lenient business record exception. And in any event, even if there was an exception that applied, introduction of the certificate would violate the Sixth Amendment. This was essentially the Supreme Court's holding in the Melendez-Diaz case, right? So this is mirrors that case. This is an affidavit falling within the core class of testimonial statements. Note too that under Bullcoming, the state in this case can't simply substitute another lab tech for the one who performed the test. So does Williams change the result of this decision? And the answer is no, it really doesn't. The certificate is testimonial under any of the definitions offered in the Williams opinion. So just to recap, the plurality opinion was the primary purpose test, the primary purpose of accusing a targeted individual of engaging in criminal conduct. Here, the state is testing a substance seized from a particular individual. So we don't have to worry about that. Under Thomas's formulation, this certificate is formalized because it has been notarized. And then, of course, under the dissent, the certificate was prepared to establish some fact in a criminal proceeding and under circumstances which would lead an objective witness reasonably to believe that it would be available for use at later trial. So many laboratory reports like this one remain testimonial under any of the tests articulated by the Supreme Court justices. As the book indicates, however, there are some instances in which there is more uncertainty, and we just simply need to await for further ruling on these. So one policy ethical question I'd like for you all to think about and consider with regards to this topic. What if you all were prosecutors? How would you handle these particular rulings? Doesn't the Sixth Amendment impose sort of a huge burden on prosecutors? I mean, how will they get the lab analysts to appear at all of these trials? So I think one answer is that defendants are often willing to stipulate that a particular substance was cocaine or heroin or whatever drug you have, or to agree to admission of a certificate. If the substance really was cocaine, then having a live witness there at the trial to underscore that fact doesn't really benefit the defendant. On the other hand, if there is some doubt about the nature of the substance, the analyst certainly would have to testify in court about the substance. Some states have enacted statutes that allow the prosecutor to announce its plan to rely upon a certificate at trial. The prosecution must then file an announcement by a specified date before trial of its intention to do so. If the defendant wants to cross-examine the analyst live, the defendant must then file a formal objection. And in dictum, the Melendez-Diaz majority approved of this type of arrangement. Melendez-Diaz and Bull-Cumming do give defendants some sort of leverage in plea bargaining. If the defendant insists on going to trial and then forcing the prosecutor to call the analyst, that can make the trial pretty onerous for the prosecutor. And if the analyst is no longer available, for example, if the analyst has died or moved away, can't be found, the prosecutor might actually have to drop the case. But this is true with any type of witness in a criminal trial, so this is always going to be some type of leverage that a criminal defendant has in plea bargaining. Another question to consider is what obligations, if any, do prosecutors have to think about Sixth Amendment limits on evidence? Should they simply follow the latest court ruling, introduce as much evidence as the court will allow, or do you think that they have this greater duty to think about constitutional constraints on their own, regardless of any court opinions? I mean, they are sort of there to do justice, right, and not just to win cases. So, for example, before Crawford, prosecutors frequently would offer sworn testimony from witnesses who had testified before a grand jury but were unavailable for trial. And courts often upheld this practice under the residual hearsay exception, but it really does seem dubious, and of course Crawford solidified that it was problematic. So should prosecutors have refrained from offering this type of testimony? Crawford was not applied retroactively, right? So all of those defendants who were convicted based on those types of statements before the Crawford opinion came out are out of luck. Third, another question, what ethical obligations does a prosecutor have when an area of law is evolving? So for example, before Melendez-Diaz, should prosecutors have refrained from introducing lab reports without making the report's author available for cross-examination? Or was it appropriate to continue with these reports until the Supreme Court expressly forbade it? Note that many convictions occur in the years that it can take for an issue to rise to the Supreme Court, and then the Supreme Court will often refuse to apply cases retroactively. So applications of Crawford will only apply to convictions that have not yet been finalized. So if a prosecutor thinks that the Supreme Court will probably hold a category of evidence unconstitutional under Crawford, but the court has yet to act, how should she proceed, and what if she is not sure? So those are just some policy and ethical questions that I would encourage you to think about and to consider as they relate to this important topic of the Confrontation Clause. Okay, well that concludes our lecture 58 on the Confrontation Clause. It's an important one, so please do not forget to head over to the discussion thread that I will post in the folder for class 24, and let me know or let your peers know if you have any thoughts or any questions about the lecture or the reading for this class. I will talk to you next time. Thanks.